Welcome to Washington in Focus Daily. I'm Tim Klauser. Tonight, we're taking a closer look at the Washington State Supreme Court and the issues shaping some of this year's most closely watched judicial races. Plus, the Center Square's TJ Martinell joins us to discuss allegations of theft at the Glen Children's Center and what those claims could mean for oversight and accountability. We begin tonight with the races for the Washington State Supreme Court. Position 5 candidate Dave Larson recently joined me for an interview to talk about judicial independence. Judge Larson, you've spent decades as a lawyer and judge. You've run for the Supreme Court before. Why this race and why now?
Well, it's kind of a pivotal time in history, actually. It's one of the things I say on my video voters guide tape is we're so interested in getting our way that we've lost our way. And the judiciary is a very important part of our society in the sense that it's the third branch of government. We're supposed to be the lighthouse in the storm, not a ship lost at sea. I think what I'll add to the Supreme Court is some stability and confidence in that, at least from my perspective, decisions will be coming from the right place for the right reasons. One of the things that when I retired at the end of 2025, the thing that was left unfinished is kind of really getting the Supreme Court to understand the implications of their decisions and what it has on what the implications of those decisions on cases as well as court rules, what impact that has on trial courts, the lawyers, and then the community ultimately, and the people we see in court. And I think that perspective is missing in the Supreme Court. And my fifth grandchild was born, and I thought, when he asked me, Grandpa, what did you do to make things better? Then I felt like I had a duty to step up at that point to if I have something to add to the discussion and to the equation, that I have a duty to step forward. So that's why I've run this time.
Your campaign says that you've worn the black robe for 18 years. We know some of your opponents, or Justice Angelis themselves, he recently joined the bench without any experience as a judge. I know several Supreme Court justices in the past joined without prior judge experience as well. Why should voters treat that as important or decisive in a race like this?
Well, like I say, the NFL doesn't have former players do an instant replay, right?
Mm-hmm.
There's a reason for that, because you're judging the calls of a referee. And at the Supreme Court level, you're judging the calls of trial judges. And without ever being a trial judge, how do you know what goes through the mind? And I tell you, from being a trial lawyer for 23 years, handling significant litigation in state and federal court, and going to the bench, there is a substantial difference. It's like describing to somebody what it's like to be a parent. Until you're a parent, you really don't know.
Do you think the lack of experience on the bench leads to more of these unfunded mandates like we see through the new caseload standards, or cases like the Blake decision where we declared the felony drug possession statute unconstitutional, and now we're having to resentence all these people across the state?
Well, Blake was motivated by ideology. I'll say that flat out. In fact, Justice Stevens, the Chief Justice now, she wasn't then at the time Blake was decided, as I recall, in her dissent, called out the majority because the majority came up with arguments that the lawyers didn't even come up with to overturn the drug laws in Washington, drug laws that have been upheld twice before, and that the U.S. Supreme Court was said that were constitutional. Strict liability is what it was called. I don't personally. This is an example of how a judge is supposed to work. I didn't personally like the idea of strict liability, which means that having possession doesn't matter whether you knew it or not. You're guilty, right? There's some exceptions that were carved out, but I don't like that. But as a judge, that's not my role to decide. It's the legislature. You could certainly make some comments in the case. This isn't fair. We're going to uphold it. The legislature consider getting rid of strict liability, but you don't legislate from the bench like that and put your own personal views where you as the judge are coming up with arguments the lawyers didn't even come up with, to throw this whole state into a spiral. Essentially what they did in the Blake case is the same thing Oregon voters did by popular vote that would turn out to be a disaster. And it was a disaster in our state too. It still continues. We're still recovering.
So A lot of candidates, at least in their TVW voter guide statements that they put out, they preach that they're coming into the race hoping to clear the field of any political influence, essentially. But you have Justice Angelis. He recently joined the bench. He worked at K&L Gates for 26 years. Governor Ferguson said himself that he worked with Angelis at K&L Gates and had teamed up on a case or two in the past. Senator Jamie Peterson, he also practiced at the firm, sponsored the new income tax, endorsed Angelis, and Angelis had previously donated to Peterson's campaigns. I mean, as voters look at a race that could affect future tax cases, should they view those as a recusal issue, in appearance of fairness concern, or just simple political context in the race?
Well, I'm an advocate for better judicial elections because these kind of issues, the public deserves to know more about how the judiciary works, and we keep it a mystery, and we shouldn't. It's a direct assault on judicial independence to appoint campaign contributors, because he's also appointed to contributed to Governor Ferguson. It's a direct assault on judicial independence to have somebody that's been contributing to your gubernatorial or your campaigns, attorney general, governor, since 2009. He's Theo, Theo Angelis is a decent guy, not trying to attack him, but he's already given to Governor Ferguson for the 2028 election, right? And so you're going to have a justice sitting on the bench hearing the income tax case where he's donated to Moncadingra, Jamie Peterson, Governor Ferguson, and even Nick Brown, the attorney general, and that justice is sitting on the bench. I don't know. It's very somebody that's very cares very dearly about judicial independence, and it's troubling. And the reason judicial independence is so important is that's how we become the third branch of government. The judiciary is supposed to be a backstop, not an open gate, right? And so if the governor or the legislature steps out of line, or the attorney general or anybody else, your job is to make sure they don't step out of line. If they're in bounds, if everything else, well, then it's a strike, right? And they're good to go. But if there's something that's wrong, the Supreme Court has to be not only in reality be that backstop, but appear to be that backstop too. So those kind of influences are troublesome. The other thing we run into in judicial races is I go after everybody. I go after Democrats, Republicans, business, labor, and a lot of the candidates only go after one political party. And it's and just very narrow. And I think voters need to look closely at who they say they're endorsed by to see what, that they're keeping it very partisan versus reaching out to everybody, which I think is essential for judicial candidates to do. Even if they don't get the endorsements, the fact that they've reached out to everybody, that shows balance. And I've been endorsed by parties people haven't heard of, by the Forward Party, which was started by Democratic presidential candidate Andrew Yang, and Republican governor from New Jersey, Christine Todd Whitman. Also been endorsed by the Cascade Party, which is started by Nirvana bass player Chris Novoselic. I always get his name wrong, but those are both parties that are trying to be remedies for the kind of the rancor that's going on between the two major parties. And so those endorsements, I think people should look to as evidence of balance, and that's what we need for judges. So somebody can say that they're trying to get rid of partisanship, but really look deep into who they really have sought support from, not who they're getting support from, who they sought support from. And that's significant.
Given the close connection and campaign funding donations going on between Justice Angelis, who the governor recently appointed, Governor Ferguson, who signed the income tax, and Senator Jamie Peterson, who wrote it, do you think that Justice Angelis should recuse himself in a ruling should this issue reach the bench in the future?
Well, under the court rules, so I wrote an op-ed in the Seattle Times in 2024 that's worth a read, I hope, because I am advocate for creating what's called the Judicial Elections Commission, which would rate candidates, and the governor can only pick from the top three, can't pick people that are their campaign contributors or friends or whatever, unless they're in the top three, obviously. And then we've been doing that with civil service forever. It's the rule of three, it's called. And in that op-ed, I wrote that I'm in favor of a mandatory recusal, where if somebody contributes, you're recused. The way it works is that the first thing that has to happen under the current rules is the opposing lawyer first has to object. Okay. And then the judge or justice in this case would then have the discretion to say, no, I'm okay. I can still hear the case. There's no mandatory part of it. So he doesn't have to recuse himself. Your question though, is should he? My position is there's so many cases involving the government that come before the court that political people that have donated politically to partisan candidates should not be appointed to judicial positions. That's my position. That's how important. So in other words, he should have never been appointed. People have every right to donate to political campaigns, but when you're asked to be part of the third branch of government that's separate, you should not be sitting on the bench if you've given significant campaign contributions or any kind of campaign contributions to people who have cases on a regular basis before the court and laws that have been adopted by those people, that type of thing. So I don't think it's appropriate. And this isn't the other thing that's mentioned in the op-ed is Governor Inslee, and this would be wrong if it was Governor Larson. So this isn't an attack on Governor Inslee. It's an attack on our current state of the law. When I wrote the op-ed in December of 2024, 83% of the bench were appointed by Governor Inslee with no check and balance. It's not like the federal system where the Senate has to confirm. The only confirmation is a contested election. There was only 30 contested elections and about that many. So about 172 of the 207 were appointed by Inslee. So 140 judges are sitting on the bench, never been scrutinized by anybody other than one person. And it's ironic, the 250th anniversary of the Declaration of Independence, one of the grievances was that the king got to appoint all the judges. And so here we are. If you're in a county also, if you're a county over 100,000 people, if that appointee doesn't get an opponent, they don't even show on the ballot. So you're not even able to write in. And the reason that's so important is because you can't imagine if it was the legislature that if somebody resigned, and the pattern is judges will resign before the end of their term, which allows the governor to appoint. So imagine if the legislators develop that pattern and they resign and let the governor appoint a new one. So 83% of the legislature were appointed by the governor. What would you think about the legislature, right? And so right now, the judiciary is the third branch of government. Same analysis should be used. Right now, 6 of the 9 justices were appointed by a governor first, and only 3 were elected, including my opponent from 2024.
And I know Justice Melody, she was also recently appointed. She's not running against you. You guys are running for different positions this year, but at the same time, she was also recently appointed. She worked under Ferguson when he was the Attorney General at the Attorney General's office. She's received strong endorsements from people like the Solicitor General, Noah Purcell, and at the same time has received thousands of dollars in campaign donations from AGO staffers. Does that raise any red flags for you at all, considering that she might hear the income tax case in the future and her coworkers that potentially might be defending the law are funding her?
Well, it's certainly. So the thing is, the casual observer from the outside looking in goes, can I have confidence that this person's independent? Right? And that's where the issue comes in, is when you appoint somebody that close to you and you have unfettered discretion on who you appoint. It's not like it has to go through the Senate, has to be confirmed by anybody. It has to be confirmed by voters this year, which is fortunate that the voters get a say. But it just creates huge competence issues when you have that power and you appoint people that close to you to be on the court. That's just a problem. It's just as an appearance problem. The difference between Theo Angelis and Colleen Melody is that there's no evidence that I've seen that she has donated to partisan candidates that have significant issues before the court. Whereas the difference is Colleen Melody hasn't expressed her bias by donations the people that have appointed her like her and express a bias, right? But she hasn't expressed a bias. Where in the case of Theo Angelis, his pocketbook has expressed a bias for particular groups of people, and only one political party that have significant litigation that's coming up before the court. That they are the prow of the ship on. They're the public face of some of these issues. So that's the distinction between the two. But it's still a problem and that's why there has to be that if we're not going to change the Constitution to have it confirmed by the Senate or some kind of confirmation process, there has to be a safety valve that prevents the governor from appointing people that are close to the governor to these kind of positions, because they become the incumbent. Even I was interviewed yesterday, and somebody even talked in terms of Theo as having judicial experience. He's been on the bench 2 months, and they are already considering him to be somebody that has judicial experience. And so that factor of putting that person in, and now they're the incumbent, is a lot of power. And if you don't use that in a way that's responsible and that builds confidence in everybody across the board, then I think there's problems. And right now, I think Governor Ferguson was concerned about the confidence in the judiciary, but he's only concerned about the confidence the narrow group of people have in the judiciary. He's not concerned about everybody having confidence in the judiciary. And that's that role of being a trustee of that responsibility under the Constitution, I think requires a higher level of discretion when making those choices to make sure that everybody has that your choice shows the maximum amount of, that gives the maximum amount of confidence to the public that particular appointee is going to be fair and impartial.
As voters weigh their opinions on this year's judicial elections, questions about how justices approach the laws and the limits of their authority continue to shape the conversation. Justice Theo Angelis was appointed to the Washington State Supreme Court earlier this year and now faces voters for the first time. In our next interview, he discusses his time on the bench, the responsibilities of a Supreme Court justice, and why he believes the courts must interpret the laws and not create them. How would you describe your judicial philosophy in plain English, especially with high-profile cases where voters may be watching for signs of influence or conflicts of interest as those approach the court?
Sure. I would say there are two primary facets to how I approach every case. One is that I try to read everything. I'm an all of the above person when it comes to judicial philosophy and interpretation. Of course, we start with the text because that's how the law is given to us. And it comes to us in either a constitutional provision or a statute. And then we also consider the ways in which the statute was passed. For example, if someone is saying you should interpret this statute to mean X, and if that was actually proposed but rejected during the process of passing that bill or during the framing of our Constitution, probably that's not how we should interpret the statute, for example. So I do consider the history of how the statute or Constitution came to being. Then I consider workability issues as well, because there's a famous saying, I'm not sure whether it was public or not, or how it was said, or who said it, but there was a case in which one of the results would be that we would outlaw every city in Washington state. And so that's not really how we're supposed to interpret our Constitution as a suicide pact. So I do think about workability of our law, and of course consistent with the law itself, but at the margins we think about whether what rules we could adopt and how workable they're going to be. And the problem that was trying to be solved by the legislature, we're not as a court there to correct errors in legislation necessarily, but we're also there to ensure that the intent of the legislature does prevail when it is divinable by the text and the history, for example. So these are all important things I think about. And the facts of the case are really important. John Adams famously said, facts are stubborn things, right? And so I like to understand the factual context of every case in great detail. We're hearing some arguments on Tuesday, and I've been digging into Department of Corrections records, minutia of that, because I really want to know for this particular case what actually happened to make sure I understand it, for example. And so that's all very important to me. So my philosophy is learn everything and really think hard about it.
how do you approach court rules that may carry significant costs or operational consequences for cities and counties?
So similar to the way that I approach cases, I approach rules with the idea that I'm going to get fully up to speed on all of the issues. So for many of the rules, like we have an important rule regarding bail reform that's going to be considered by the court at the end of this month. And there have been over 900 comments submitted with respect to
Mhm.
that rule. I'm reading them. I'm sitting there reading them. And to the extent people are interested in talking to me about the rule, I'm happy to talk to them as well. There are justices who are concerned about, they really want all communication to come through the papers. And of
Mhm.
course, in a case, we don't have what we call ex parte communications. We don't talk to one side or the other without giving the other side a fair opportunity. But when it comes to our rulemaking process, I want to get as much information as possible. And I've encouraged groups of every type, from contractors to unions to civil rights community representatives, to come
Mhm.
and offer information and to submit comments for the rules, because they are really important. It is a key part of what we do. Administration of justice in Washington is in some ways the most important thing that we do as the
Mhm.
Supreme Court. And it bothers me that people of middle class and working class means are locked out of our justice system often. They can't really get a fair shake if something's been done to them that is illegal. And
Mhm.
so that's what I think is an important way that our rules need to be used, is to provide genuine access to justice. And in certain circumstances, that makes things more or less difficult for people, and we need to take that into account, but we also need to continue to strive to rebuild and reform our system so it reflects our best ideals.
So I want to ask you a little bit about judicial independence and campaign donations, because Judge Larson had brought that up in our interview yesterday. Um, Again, not asking how you would rule on, like, to say, the income tax case or anything else, but he told me that appointing people that have contributed to people that drafted legislation that the court might have to consider a case on, or signed by the governor when they had worked with them, that's a quote unquote direct assault on judicial independence. And he suggested that you shouldn't have been appointed to the court because of prior political donations. Was wondering how you respond to that.
Sure. So obviously I haven't heard the specific statements, and I
Mhm.
take the canons and the judicial rules for ethics very seriously. They're very important for faith in the judiciary. We want people to believe in our court system. I've made donations over time to people who I've met and respect. That will not prevent me from ruling against whatever interest they are seemingly aligned with in any way. All of that falls away. Judge Larson and I were actually at a panel recently where we were talking, and we were asked about our faith.
Mhm.
And my faith is very important to me. I try to go to church as often as I can. I try to live my faith, but I park that at the courthouse door. And I, like I said, I use a lot of different tools, important technology tools, to try to keep bias out of my decision making. And so I don't think that either the people before we came to the bench that we may have donated to or associated with, or those who are supporting us now, really makes a difference. I think
Mhm.
you're not really being a judicial officer if that weighs on your decision making in any way. And I'm proud to be supported by a broad cross section of Washingtonians, from the business community, from the labor community, from the progressive community, from those who are, on seen at least as being more on the political right versus the political left. And I think that falls away. A lot of what it means is sort of relationships with people that I've worked with over time, that I've come to respect their work ethic and what they're trying to accomplish, both on the left and the right. So none of
Mhm.
that really seems disqualifying to me in any way. And none of it really influences the way I approach a case, which is, intense digging into the facts and the law. And
Mhm.
usually the answer presents itself to me after I've done that.
So, you, Governor Ferguson, and Senator Peterson, at one point or another, you guys had all worked at K&L Gates, and briefly together at the same time. Again, Peterson had drafted the income tax, and Ferguson had signed it. I was wondering if you could kind of explain to voters who see that connection and kind of maybe put off about that, and explain the nature of your work with them at K&L Gates and what they should make of those relationships now.
Yeah, so I don't think um, people should be concerned at all. It's a little like working at, I think when you work in the legislature, for example, you spend a lot of time with different colleagues. That's a little different because it's political, but we didn't. I think I worked on one case involving a question of the First Amendment with Governor Ferguson when he was at the firm. There was a question about whether people could refer to their opponents in the voters pamphlet, and that ended up going into the federal court system and even up to the Ninth Circuit. And we had represented the Seattle Ethics and Election Commission on that issue. But it wasn't a partisan issue at all. It was really just good government and free speech rights and how they operate. And with respect to Senator Peterson, he actually was a mentor to me. We clerked for the same judge, the same Republican appointed judge in Washington, D.C., 5 years apart. He was a mentor to me early on in my career and helped me understand just acclimating to a law firm. But we never did any work together, or not very much work together, because he was a corporate lawyer. He was working on deals and those sorts of things, and I was a litigator. So we really didn't spend time working on particular cases together. Conversely, when I was clerking at the U.S. Attorney's Office during law school, I worked with Diane Tibelius, right, who was, I think, a chair of the GOP party. And there are a lot of lawyers who have a lot of different political viewpoints that you work with on cases. And when you're a lawyer working for a client, it's the client's interests that always come first. And so politics never really came into our work. It was all about who the client was and how we could advocate for that client in the best way possible. So I understand why people note that. I don't in any way judge people for sort of asking about that connection, but for me, it really just sort of falls away and has nothing to do with the way I consider cases.
Mhm. You had mentioned earlier in the interview your process for kind of considering whether to recuse yourself or whether or not you would have a bias in the case. With the relationships with Ferguson and Peterson, would you recuse yourself on something over the income tax, or considering your relationships with them in the past, is it a factor that you would consider in that list that you had kind of discussed with me?
Well, if someone asks that I consider whether I should recuse myself, I always consider it very, very seriously. I had someone recently request that I recuse myself from a case because it involved a judge who had been at the firm when I was practicing there as well. Generally speaking, the fact that in a 200 lawyer office of a 2,000
Mhm.
lawyer firm, the fact that I worked at the same firm with someone and even maybe worked on a case with that person usually would not be considered enough to require recusal. It's not usually the kind of situation that would lead someone to reasonably question my impartiality. It's similar, the prototypical example, of course, is you have a financial interest in a case, right? If
Mhm.
the firm were a party, because I so recently was employed by the firm, absolutely. Or if the firm that I worked at were a part, I recused myself very recently in a case involving our law firm, and I did not participate in it because the firm was litigating that case. That's exactly the kind of situation where I would. And so if the firm were to appear as one of the law firms representing a party in whatever case it is, it doesn't matter what the issue, then I would not appear on that case. But just because someone is associated with an issue that I practiced with years ago, I don't know, frankly, whether any of the Supreme Court justices would be able to hear a case with that standard because it's kind of a medium-sized legal community in the Northwest,
Mhm.
and we all have met each other in one form or another over the years. I worked closely with the Attorney General McKenna on his Youth Internet Safety Task Force. He appointed me to that task force, and I was the co-chair of the Law Enforcement Committee. We proposed some legislation that ended up getting passed. And I worked very closely with Rob McKenna on that, was proud to have done so. And because we were really fighting for children and their protections online. So that's the kind of situation where, if he were to appear, I would not have to recuse myself just because we'd worked together on his Youth Internet Safety Task Force.
So Rob McKenna, he's also one of the people behind the lawsuit that's in the lower courts right now, challenging the state income tax. Are you saying that if that case comes to the bench while you're there, that that's not necessarily a situation where you immediately see a need to recuse yourself?
That's right. That's
Okay.
right. Just because, I worked on his Youth Internet Safety Task Force, I would not see that as a basis for having to recuse myself.
But not just McKenna, but Peterson and Ferguson as well. Kind of the trio, considering that on both sides of the issue, there's people that you had worked with.
Yeah, I think I'd want to see if someone were to file a motion or ask me to consider it. I'd want to look carefully at what they said. So maybe that's probably the best answer.
Mhm.
Is like all things, I'd like to see what someone raises and the authority they cite, and then I would make the decision at that point.
Yeah, so the judicial conduct rules also say that judges must avoid impropriety or in a appearance of impropriety, but they also say that judges shouldn't use recusals to avoid difficult or controversial cases. Was wondering how you balance those two obligations, especially considering what might be coming to the court in the next year or so.
Yeah, I mean, I think, the canon that you mentioned about not trying to use recusals to avoid difficult cases is an important one, right? And I think that judges and justices have an obligation to hear the cases and not create a situation where the court is short-staffed in some way or to duck an issue. And I think that's what the voters expect is that we're not afraid to to rule one way or the other. And frankly, I don't care whose ox is gored by the decision that I come up with. I'm going to look very carefully at the papers when they're submitted, and I'm going to spend a lot of time with the founding documents for our state constitution and really trying to understand the history. We had a case recently involving the same tax and the referendum power. And one of the things I did is I went back to 1915 when the amendment in question was created, and I read every single case that as the Supreme Court have written on it because I wanted to understand it. And in that situation, there was an unbroken line on those cases. And there certainly are policy arguments you could make for or against a particular rule, but I focused on the language of the law and how we've interpreted it over time. And it was important to me to follow our precedent, and which I thought really yielded a clear result in that case.
Mhm. Without getting too into the weeds, because I don't want to get you in trouble, you guys had already considered the referendum case over the income tax. You just mentioned kind of doing some research into the prior rulings going all the way back to 1915. So have you already done a considerable amount of research on the income tax issue as it relates to prior Supreme Court rulings?
Only on the issue of the referendum power.
Gotcha.
So that, and then, and that, and again, the canons we've been talking about, the judicial ethics rules we've
Mhm.
been talking about, allow me to sort of talk about the cases that we've already decided and that are finally decided. But they also caution me that our opinion really should speak for itself. And so
Mhm.
that's, I think, you'll see that it was the whole court issued it together. The Chief Justice signed it, but it was a unanimous opinion from our court. And we explained how the history of the referendum authority and power and
Mhm.
why we thought it yielded a certain result. That I think that has, really nothing to do with whatever other legal questions might come before us on the income tax.
Finally, tonight, allegations at the Echo Glen Children's Center are raising new questions about accountability and oversight within Washington's juvenile rehabilitation system. The Center Square's TJ Martinell has been following the story and joins us to explain what is known so far, how state officials are responding, and what the allegations could mean moving forward. Welcome to another episode of Washington in Focus. I'm your host, Tim Klauser, with the Center Square's Washington State investigative reporter, TJ Martinell, here to talk about whistleblowers coming forward about alleged theft at the state's Echo Glen Juvenile Rehabilitation Center. TJ, what's going on here? What's being stolen, and why should taxpayers care about this?
I think there's a couple of reasons why taxpayers should care about this. One is taxpayer dollars are being misused for personal use, according to the allegations made in the story or in the reports, which I included in the story. And the other one is that the fact that DCYF wouldn't talk to me, and then the state auditor in my initial story about this said, "Oh, we haven't received any word from DCYF about there being alleged theft." Well, I just found out that they were notified by two whistleblowers that they're mentioned in my news story. So they had somebody tell them that this was going on. And then I reached out to the state auditor's office, say, you want to talk to them, do an interview and say, hey, like they came to you. One, why didn't you tell us about that when I reached out for my initial story? And two, what did you guys find? Again, it begs the question. If they were notified, did they do an investigation? If they did an investigation, did they find anything? If they didn't find anything, why didn't they tell us? So we're talking about government accountability. We're talking about misuse of taxpayer dollars. We're talking about fraud. We're talking about all sorts of different things that is just really it makes you wonder, how bad is this? Because if this is, it's not a huge amount of money compared to the amount of money that the government in our state spends. It's $56,000. But at the same time, somebody reported it to DCYF. They reported it directly to Secretary Sen. They reported it to the the state auditor's office, and neither one of them want to talk to me about it. So what's going on? I mean, that's the question. You're asking me what's going on. But that's the question I'm asking myself.
Yeah, TJ, you say in terms of the total state budget, not a ton of money, but at the same time, we're talking, you just said 56. I think your article says $57,000 in alleged theft. Are we talking about cold hard cash out of a safe at this rehabilitation center? Or are we talking like operational supplies?
We're talking about them they're taking money, using it to buy things that they're using for personal use rather than for, you know, for official business reasons. It's like, it would be the equivalent of somebody claiming to go on a business trip and they're actually going to see, I'm trying to think of a band that I have no idea what bands are out there nowadays. Let's say they're going to a band that they're really fan of, 1,000 miles away, and then they build their company and said, "Oh, that was a business related expense trip," or something like that. It's misuse. It's trying to steal from the company or whatever it is. Or if they're using company property for, their own personal use, it's a misuse of company property. But in this case, it's taxpayer dollars. So that's the problem that's going on here. But the bigger problem is the fact of the lack of government transparency. DCYF, like I said, wouldn't talk to me, wouldn't provide a statement. They wanted to know more information. I was like, how about we just talk on the phone about what's going on? Then I requested an interview, and I may hear from the state auditor's office. I gave them a couple days, but I did ask them to respond for a good dates and good times by today, and I've not heard anything from them. But why didn't they initially come out and say, yeah, we weren't contacted by DCYF. We were contacted by a couple whistleblowers. We looked into it. We didn't find anything. So just letting you know for your own edification. The fact that they aren't even saying that really raises questions about, to what extent did investigate? What did they find? And, the allegations are kind of serious. One of the whistleblowers said that state employees at the facility were misusing money, and it was being covered up by higher up. So how high does the corruption go in this case?
Well, TJ, one of the whistleblowers you referenced in the story did list a few things that the money might have been used for.
Right.
I particularly find this interesting. We're talking kombucha, as if the alleged theft of taxpayer funds didn't cause enough of a stomachache, and then 23 pounds of yeast. I mean, usually you hear about government fraud, waste, and abuse. You think of people taking money out of a safe or siphoning money out of a social service program. I mean, we're talking about 23 pounds of yeast. This is a different kind of theft than I think I have ever seen.
Well, I mean, if you have a relative or a spouse or whoever who owns a brewery and they're trying to brew beer or they're trying to do, alcohol, yeast is kind of important. So I'm just saying, that's one of the possibilities of how it was used was, they were ordering yeast so they could help either their own business or someone else's business when it comes to the, brewing beer. As far as kombucha, well, the problem is there's a lot of health code violations or things that you can't claim that they were business related because the food they were ordering is supposed to be for the kids who are in the detention facility, and yet a lot of that stuff is not allowed. I can't remember which one it was, but the fact that they had so much of it, you could theoretically make alcohol out of it. Aside from yeast, I think the yeast. Oh, that was the yeast where you can make this like alcoholic drink that inmates will make, or all that kind of stuff. I mean, anybody who's kind of researched history knows that, desperate times call for desperate measures. Men will make alcohol out of anything, jungle juice during World War II or whatever it was. But I mean, if people are wondering why would they buy and misused taxpayer dollars to buy 23 pounds of yeast. I guess as they were making alcohol of some kind. We don't know. And, it'd be nice to talk to the DCYF and state auditor's office and say, what did you find? What was the yeast for? Were they making a big loaf of bread?
Yeah, well, it must have been some expensive yeast and kombucha and whatever these specialty drinks and coffee that they were allegedly buying. But TJ, appreciate you covering this. It's a particularly interesting case, and again, something that we might not have caught had you not filed those public records requests. Appreciate your reporting on this, and we'll continue to cover it as it comes out. And for anyone hoping to read those articles, you can catch them at thecentersquare.com. Otherwise, thank you for joining us for another episode of Washington in Focus. That's all for today's edition of Washington in Focus Daily. For more stories like this and the ones we didn't get to, you can read them at thecentersquare.com. I'm Tim Klauser, and we'll see you next time.